Okay. Next topic is trial by jury. Now, it's sort of fitting that we're virtually ending with this since we started with it, the Duncan case. Of course, it's a different part of the Duncan case that is being discussed now rather than the part of it which was discussed in the very first day of the course. Now we're talking about the substance in terms of the constitutional right to a trial by jury. And this is a 1968 case, and it talks about the circumstance in which you do not have to have a jury trial. Now, what I mean by that is that we all know the Constitution has a right to a trial by jury, and what Duncan does is say that you have a right to a trial by jury if the maximum possible sentence involves more than 6 months in prison. But therefore, what it says is that you do not have a right to a trial by jury if the maximum possible sentence is 6 months or less. So the case says you only have a right to a trial by jury if the maximum possible sentence is over 6 months. Now, that means, of course, it's very easy to give you a hypo and says, well, the defendant is being charged with larceny, and he can get 6 months in prison. He says he has to have a jury trial. Is he right? Answer, no, because the Supreme Court said the constitutional right to a jury trial is limited to situations in which the maximum possible sentence is more than 6 months in prison. But that then leads to the next issue factually. You know, I stole something from a store, and then I stole something else from the store. I can be charged with a misdemeanor theft to the first one, and I can be charged with a misdemeanor theft to the second one. They're two separate crimes, correct? Stealing the first thing, stealing the second thing. On each one, the maximum possible sentence is 6 months. So the prosecutor says, no jury trial because the maximum possible sentence is only 6 months. I say, wait a minute, 6 times 2 is 12. The maximum possible sentence is not 6 months, it's 12 months because each charge has a maximum possible sentence of 6. And I could be sentenced what's called consecutively to serve 6, and then after the first one to serve the second 6, that's 12. 12 is more than 6. However, as you know, I lose because in Lewis and in the discussion on 1150 to 1155, the book explains how the court essentially says it's a charge by charge right rather than a prosecution by prosecution right. Charge by charge versus prosecution by prosecution. What I mean by that is when you're prosecuted, you may be prosecuted at one time for many crimes. But each one is a single prosecution, even though they happen to be joined together. And the constitutional right only applies when for a particular offense you could get the longer sentence. Now, whether that practically reflects the reality of the reason for a jury trial or not, at this point is relatively immaterial because it's quite fixed and there hasn't been much incentive for the court to reconsider that ruling. So, let me go back now to something more fundamental about jury trial right rather than that, if you will, detail coming from Duncan. There's an old line. A jury is 12 men, tried and true, who will hear the facts of the case and arrive upon a unanimous verdict. Now, this isn't such a recent statement, and the reason is that it's 12 men, tried and true. Well, the 12 part isn't necessarily accurate. The men part isn't necessarily accurate. who will arrive upon a unanimous verdict. Unanimous verdict isn't necessarily accurate anymore either. Because in the last 30 years, the Supreme Court has considered a series of cases involving the composition of a jury and involving the functioning of a jury. And each of those issues, male-only jury, unanimous jury, 12-person jury, has been considered by the court. And so let's consider this sort of one at a time. The first issue that the court considers, once we go beyond the issue of when you have a jury trial, which relates to the penalty, is what is a jury? Now, what happened here, essentially, is money raised its ugly head in the toils of justice. Now, I just talked about plea bargaining, where, of course, money comes into play in inducing prosecutors to give defendants lesser sentences because you can't possibly prosecute all the crimes. You don't have enough courtrooms, lawyers, and judges. But this is a different way, and it's not around where we live, which is a densely populated area with, so to speak, more people than you know what to do with. Let's talk about going out west where the spaces are large and the population is low. You know, finding 12 people to try a case isn't all that easy. And then finding 12 people who are qualified because they aren't a relative of the defendant or a relative of the prosecutor, a small community, especially communities maybe where people have a lot of kids, not so easy to do. So some jurisdiction came along and said, why do we need 12? And they said, we'll have a jury of 9. Well, actually, the first case was 10. We'll have a jury of 10 that the Supreme Court considered. And then other jurisdictions said, oh, that's a nifty idea. But you know something? What also causes a whole lot of money is retrials when the first jury can't decide. And you know, in civil cases, we don't require juries to be unanimous. We haven't required it for decades and decades. So why does a jury have to be unanimous? So we now have the following question. What's wrong with a 9-person jury and a conviction can be achieved if 3 vote not guilty? So it's 6-3. What do we need unanimity for, in other words? So, what do we need 12 for? What do we need unanimity? Well, the Supreme Court dealt with 12 first, and basically, they asked themselves the question, where did 12 come from anyway? I mean, why weren't juries 10? Fingers, hands, that's 10, right? Fingers and toes together, that's 20. Where did we get 12? Sort of no one knows. It's just sort of is because it is, rather than the months of the year, so juries in the months of the year go together in some way. I mean, there doesn't seem to be any particular compelling logic as to why it should be 12. And the Supreme Court said, well, it doesn't have to be 12, because, see, there is, however, a constitutional principle here. A jury should contain a fair cross-section of the community. Now, if the community is, like Sweden, until recently, that is, I mean, sort of everybody had the same names. In Sweden they're running out of names, and people who want to change their name are not allowed to change it to about 50 names because there's so many people with the same name that they want to spread it out and change it. I mean, we have a lot of diversity here. So you're never going to have a fair cross-section of the community. I mean, if we have, for instance, a community with 13% Hispanic, what does that compute to on a 12-person jury? 1.25 jurors? Is that going to be the top quarter, the bottom quarter? I mean, you can't have a jury of 12 people exactly representing the distribution of whatever in a community. And by the way, you have men, you have women, you have people of different ethnic background, racial background, religious background. You're going to have sort of a little bit of everybody on the jury. So when we say the jury has a fair cross-section of the community, what we really mean is that the big group out of which we select a jury is going to have a fair cross-section. The whole jury. So this is a good time now to stop as we consider white hen and what a cross-section is, to talk about how juries are selected a little bit. And I'm not sure if everybody knows or doesn't know, and it's easier just to sort of explain it briefly. First thing you do is you have to get a big bunch of people called the veneer. And you have to get them out of the community. And indeed, the issue determining whether or not a jury is tainted by some kind of discrimination which deprives the defendant of a right of a jury that has a fair cross-section of the community on it comes not from the selection of the actual jury in the beginning, but comes from the selection of people on the veneer. And the way you get a whole bunch of people is you create a list of people in the community. So, voting lists, driver lists, people who pay electrical bills, people who pay taxes. And by the way, jurisdiction wants to have a big list rather than a small list, because the bigger the list you have, the easier it is to find people who are going to show up to be jurors. Because even though theoretically we go and arrest you if you don't throw up, I mean, if you don't show up, it's close. So if you don't show up, we arrest you. In fact, we don't have the resources to go out and arrest hundreds of people for not showing up if routinely people ignore letters saying they have to show up for jury service. I mean, we don't have the personnel to do that. So voluntary compliance, or the belief that you have to comply, is very important. So the bigger the list, the better. Now, there are, of course, a lot of cases, almost all of which came from the South, involving selection processes that conveniently left out African Americans. And the court said, well, that's not correct. And this becomes a technically interesting issue, if you like technically interesting legal issues. Is the juror, the potential juror who's not called for jury duty because of racial discrimination, is that person's right violated? Or is the defendant's right to a jury, which is a fair cross-section of the community, is that violated? So is it a due process right? Is it an equal protection right? Is it a right of the potential juror? Is it a right of the defendant? Very nice abstract concept, but it comes out to the following detail. If it's the juror's right, who has standing in court to raise it? If it's the juror's right, who has standing to raise it? And that's why, by the way, the Taylor case is in the book, and that has to do with this. I think it's a really nifty case. I mean, it's such a residue of an ancient view of the world. And I think it's Louisiana. Women didn't have to show up for jury duty. And women were not made part of the veneer, the people who were automatically told that they had to come for jury duty. Now, they weren't excluded from juries. They just had to write a letter and say, I want to be on a jury, and then you put them on the list. And if they wanted to be on juries, when their name came up, they would be. And the defendant claimed that violated the Constitution. And the court said that's true. And also said that the male defendant, who happened to be charged with a rape, had standing to raise the issue. So he had standing to raise the fact that the women's rights were violated by being discriminated against by not being mandatorily called for jury duty. And of course, it's nice to have a scenario in which somebody is getting a benefit they want in violation of the Constitution, so we now provide them with their rights, so they're now treated just as badly as everybody else, and their special benefit is taken away from them, because I don't know a whole lot of people who want to be on jury duty. The only people who want to be on jury duty are people who are retired on a pension and don't have anything to do, and it might be fun to go down and be on jury duty for a while. Gives me something to do. Well, I'm serious. Do you say, oh, gee, I may get a jury duty notice? That's peachy keen. I love it. Who wants to be on a jury? I mean, who wants to get that notice? Nobody. No. So we imposed their constitutional rights on women and everybody else in terms of a prohibition of excluding people based upon discriminatory classification. Oh, by the way, however, there are some people we can discriminate against. Young people. You know how we discriminate against young people? We don't reconsider this big list of people from whom we grab people and tell them they have to show up for jury duty. We don't redo that except every 4 years. So if you become 18 and you're not eligible for jury duty, if we just did the list a few weeks ago, when you're 18, you're not on the list. When you're 19, you're on the list. When you're 20, you're not on the list. You're only on the list when you're 21. So we discriminate against the 18, 19, and 20-year-olds, and some 21s too, because we don't redo the list all the time. The court said that's constitutional. It's just a rational way of dealing with the burden of putting together lists. So you can discriminate against some people because there's sort of, I guess, no historic discrimination against youth. But, so you start out by getting the veneer, this big group of people, and the process by which they're selected has to be inclusive, otherwise a jury selected from a veneer that isn't picked pursuant to the right process, that jury's verdict will not be acceptable, and the defendant's conviction would be reversed. The next thing that happens is that out of the big veneer, you pick a bunch of people to go to the courtroom, and out of the bunch of people who go to the courtroom, you pick people who are going to be on the actual jury. Now, the bunch of people who go to the courtroom basically is, the people who are told to go to the courtroom. And with them come a group of 3x5 cards, which has each person's name on it. In most jurisdictions, those cards are then put in a box, usually like a wheel with maybe 8 or 10 sides, 12 sides, and it spins. And the court clerk goes with all the cards in, opens the little door, and starts taking out cards. The court clerk has just selected the jury. And sometimes the court clerk will select, for instance, if it's a 12-person jury, 12 people and maybe 2 alternates will be selected. And so 14 people will be put in seats. And the clerk has just selected the jury. The next thing that happens is that we look at information about the background of each potential juror. Now, these are often done with jury forms in which the jurors fill out information about themselves before they're picked. So we have this information about everybody. And then in most jurisdictions, but not all, the lawyers are allowed to ask the jurors questions for the purpose of getting information that the lawyers will use to determine the suitability of each of the potential jurors to become actual jurors on the case. And that's called the voir dire, or voir dire, of the jury. Now, after the background information that we have from the forms has been analyzed, and after the answers to the questions have been analyzed, the next things that happen is the lawyers start to deselect the jury. You see, lawyers don't select the jury, they deselect them because the court clerk has already selected them. And what we do is we kick people off. We don't say, ooh, I want that one. Ooh, get me that one back in the back. No, to the left. We say, I don't like him. Ooh, he's off. Okay, next. Now, I, as an attorney, have two reasons I can use to kick somebody off. And they're called challenges. They're challenges for cause, and they're peremptory challenges, which is for no cause at all. Challenges for cause exist as constitutional right. Peremptory challenges are created by statute. Now, every jurisdiction has peremptory challenges. The reasons for the two challenges are different. The reason for the challenge for cause is to remove from the jury people who, because of their background, as in they're the brother of the prosecutor, or they're the mother of the defendant, or because of firm convictions in some area, that would make it unsuitable for them to be on the jury. That is, which would lead people to think that their verdict might not be based on the law the judge gives them and the facts they heard, but maybe based on other things, other sets of values that would make it impossible for them to follow the judge's rules or to seriously consider the facts. And therefore, they'd be removed for cause. Peremptory challenges, however, do not remove people because they wouldn't be fair and good jurors as a matter of law. It's because one or the other party doesn't trust them. And when I mean doesn't trust them, one party or the other thinks that a particular juror is going to tilt for the other side. And therefore, we excuse them simply because we don't like them. And I have to tell you, the first jury case I tried, the jury convicted, which probably was not a wrong thing for them to do. But in talking to the jurors after, I found out that the first vote was 11-1 to acquit. And a very, very heavy guy who was a truck driver talked everybody else into voting to convict. It was a very long time thereafter before I left very heavy people and truck drivers on any jury, because I didn't know which factor it was, so I figured, get rid of them both. Well, the point is, peremptory challenges allow you to remove people simply because you're not comfortable with them being on the jury. And whether it's the way they look, or, and by the way, an awful lot of people said, like, somebody who comes into court with a detective book to read, prosecutors don't like them. Because in a detective book, the obvious criminal rarely committed the crime. So they're sort of predisposed to look beyond the prosecutor's case. Prosecutors don't like them. Because, they're reading a detective story. You follow me? It's not a science by any means. So anyhow, the idea of the peremptory challenge is to get rid of people who make you uncomfortable with the fact that they're there. For instance, I represent a criminal defendant. How comfortable do you think my client's going to be? That woman's son is a cop. That man's father was a cop. That man's wife is a prosecutor in another jurisdiction. Should I keep going? I mean, you think my client wants those people in a jury? You think he's going to say, "Oh yeah, that's a fair jury for me"? No way. And it's not because anything they said. It's like relationships that they have, and for all we know, the guy's father is a drunk who beat him up all the time, and he hates his father, the cop, and he hates all cops. How do we know? All we know is, his father's a cop. I don't want him on my jury. So anyhow, the veneer has to be picked as a broad cross section. The petty jury doesn't have to be a cross section of anything other than it could have been. And the clerk selects the jury, and the lawyers deselect it using charges for cause and peremptory challenges for cause and peremptory challenges. Got it? Yes.
Can you peremptorily challenge because of race?
We'll get to that later. The answer is no, but maybe. Yes.
Where does occupation fall in this thing? I had to go through voir dire when I was sitting in a jury box, and I was heavily questioned about my occupation, that I'm in law school, etc. Is that a challenge for cause that you'd excuse me on, or
no,
peremptory?
That would be a peremptory challenge. Was this a civil case or criminal case?
Criminal.
I don't know. You may be somebody who really believes in reasonable doubt. The prosecutor may not like you. You may be somebody who understands that reasonable doubt is just a standard of proof, and that some doubt is allowed. Defendants might not like you. Who knows?
But I just based on just the explanation you gave us for challenge for cause, lots of questions were based on: are you able to separate, things you've learned from being able to follow the instructions of the judge? Isn't that something?
Well, those questions are oriented towards challenges for cause.
Okay.
So now here's the way juries are selected. So let's go back to why 12. 12 men tried and true. Well, told you men's no good because we have right to fair cross section, and since 50+% are women, no fair cross section without women and essentially everybody else as well. So cross out men. What about 12? Well, the Supreme Court says we got no clue why 12, and there's no reason that a jury of less than 12 can't have enough people to be a fair cross-section of the jury. Because remember, we're not having 1 1/4 of somebody anyway, because the petit jury, that's the jury that you actually get, the petit jury, the actual jury, there's no certainty that that's going to involve a cross-section of anybody from anywhere. It's just that the chance exists because the veneer has cross-section from everywhere. Oh, and by the way, one thing you do when you're selecting a jury, and it's your turn to kick some people off if you want to, one of the things you do is you look at the information you have about the juror, and then you sort of go like this. What do they look like back there? Do they look better than these people? Because who knows? So, appearance.